Morning. Welcome to the Judicial Committee of the Privy Council, where today we're hearing an appeal from the Court of Appeal of the Bahamas in the matter of Knowles and others against the Superintendent of Her Majesty's Fox Hill Prison. The case concerns an extradition request by the United States of America, and in particular, whether the appellant's committal was invalid by reason of failure to comply with the requisite authentication requirements, and whether the appellants have been deprived of their constitutional right to have their extradition proceedings determined within a reasonable time. I'm Lord Lloyd Jones, and I'm sitting today with Lord Briggs.
Good morning.
Lord Hamblin.
Good morning.
Lord Leggett.
Good morning.
And Lord Stevens.
Good morning.
The appellants are represented by Edward Fitzgerald, Queen's Counsel, Damien A.L. Gomez, Queen's Counsel, and Joseph Middleton. Respondents are represented by James Lewis, Queen's Counsel. Mr. Fitzgerald.
Yes. Well, my lords, you have the representations, and if I can just take the board firstly to our case at page the electronic bundle, page 1630. The board already knows that there are 2 points. The authentication point, that the appellant should have been discharged because the authentication requirements in section 14 of the Extradition Act weren't complied with, and secondly, the point that they should have been discharged because their constitutional right to have their habeas corpus applications decided within a reasonable time was violated, and discharge is the only remedy. My lords, the second of the grounds is set out. That's to say, the authentication point is the one that may take the most time, and which I will be concentrating on for most of the morning. And your lordships know that there has been an earlier case entitled Austin Knowles, which related to the right to bail and the right to discovery, and you have a copy of that judgment at pages 1603 to 1613 of the electronic bundle, but it's really simply by way of background. The background facts and the procedural background are set out in the SFI and the chronology, and for the purposes of the section 14 appeal, the material facts are relatively straightforward. In very brief outline, it relates to requests made as far back as 2002, the extradition of the appellants and their co-accused from the Bahamas to the United States. They were committed to prison to await extradition by the magistrate in 2003, and it wasn't until 13 years later that their applications for habeas corpus and judicial review of the committal decisions were rejected by the Supreme Court in 2016. And then the Court of Appeal rejected their appeals in 2017. My lords, just on the authentication point to start with, the relevant facts are set out in the SFI, and in brief, the evidence relied on in the extradition request was provided by Karen Atkinson, who was an assistant US attorney and was therefore an officer of the court. The fact that she was an officer of the court was confirmed at the end of her affidavit and has not been disputed. Her evidence was given on oath, and so it was subject to the authentication requirement in section 14(3)(a) of the Extradition Act. And just briefly by way of introduction, before going to section 14 and the actual key documents, we say her affidavit was important for 2 reasons. Firstly, without it, the expert evidence on foreign law to establish that these were extradition offences and that no statute of limitations applied would not have been provided. And secondly, her affidavit exhibited the statements on which the US relied to provide a prima facie case. Can I now take the board straight to section 14, But just by way of very short introduction, this being a request governed by the Bahamian Extradition Act of 1994, there were three things which we say had to be established, which are of relevance to this case. Firstly, the approved state had to show that the allegations related to an extradition offence as defined in section 5 of the Act. And if I can take you to the extradition, you'll see section 5 set out there, page 1715 of the electronic bundle. So 5.1a, without prejudice to subsection 2, any offence of which a person is accused or has been convicted in an approved state is an extradition offence. If, in the case of an offence against the law of a designated Commonwealth state, it is an offence, which it is, and then it's an offence which is punishable under law with imprisonment for a term of 2 years or any greater punishment. And in the case of an offence against the law of a treaty state at B, it is an offence which is provided for by the extradition treaty, and then it deals with the act or omission. If it took place, would constitute an offence against the law of the Bahamas if it took place.
So we're only concerned with B.
Yes, that's absolutely right.
Thank you.
Yes, and so that's 5.1b. You're absolutely right. My lord, then in addition, you'll see that there is a special provision which my learned friend relies on, 5.3, about a minister under his hand certifying the subject matter of a request received from an approved state for the purposes of section 8 constitute offences of dangerous drugs. So, my lords, that's the first provision in section 5, and then in relation to the question of a prima facie case.
Question, Mr. Fitzgerald, from Lord Stevens.
I'm sorry,
Mr. Fitzgerald. Before we move away from section 5.3, is there a certificate under the hand of the minister in accordance with that provision?
It's our submission. Sorry, I'm so sorry, my lord. It's our submission that there isn't.
Right. Does page 16 actually qualify as that certificate?
We say that's simply the authority.
And if not, why not?
My lord, we say. So you mean page 16, my lord? Yes.
Yes.
Well, we say that's simply the authority to proceed. It doesn't say that this is an approved state and certify for the purposes of section 5.3.
It doesn't actually specifically refer to section 5.3, but would it in fact comply with section 5.3?
Well, it's our respectful submission that it doesn't, because it doesn't, as it was, recite that it doesn't certify that the subject matter of the request received from an approved state is, in other words, it doesn't certify the facts set out in section 5.3. That's our submission.
Certify what fact?
It doesn't certify that this is a request received from the approved state, and that for the purposes of section 8, it doesn't certify that the offence is constituted by acts in furtherance of possession, distribution for that purpose. What I do accept, my lord, is that it refers to the fact that these are dangerous drugs offences.
Yeah.
But it doesn't. This is just an authority to proceed, a standard authority to proceed. It doesn't, in our respectful submission, constitute a certificate for the purposes of section 5.3. That is.
Well, what is the component that's missing? It states that he's satisfied. That it's constituted by acts in furtherance of possession of drugs.
I'm so sorry, my lord, forgive me.
Sorry. Section 5.3 contains a requirement that the minister under his own hand states that he's satisfied that the acts are in furtherance of possession, for instance, of dangerous drugs. I was just wondering why you say he hasn't been satisfied, when he says, I am satisfied that the offences against the laws of the United States are offences provided for in the extradition treaty, and that the acts and omissions constituting the offences would constitute the offences of conspiracy to import dangerous drugs.
Well, my lord, this is simply, if I can put it this way, this is a technical point. What we respectfully submit is this is just a standard authority to proceed. It doesn't purport to be a special certificate under 553. But if your lordship, sorry, forgive me.
Is there anything missing from it apart from the fact that it doesn't purport to be a certificate under section 5.3?
Well, it doesn't recite the fact of it being from an approved state.
And can we not glean that from joining that with other documents?
Well, my lord, you can, but the question is, does there need to be a specific section 5 certificate? And if we're right about that, then there isn't. But if your lordship is saying, well, in effect, well, he certainly deals with the question that the allegations relate to dangerous drugs. I accept that. My lord, can I return to that in due course? But your lordship is quite right to put me on the spot on that point, and I accept it. It wasn't the point that featured in the Court of Appeal or before, but I accept this point my learned friend has raised in his case, and that we need to respond. My lord, then can I then just go on from there to section 10(5), and the board has section 10(5) at electronic bundle page 1720 at the bottom, where an authority to proceed has been issued, respect of the person arrested in the court of committal is satisfied after hearing any evidence tendered in support of the request, etc., and is further satisfied where the person is accused of the offence that the evidence would be sufficient to warrant his trial for the offence if the offence had been committed in the Bahamas, the court of committal shall commit him. So, my lords, in essence, this is the prima facie requirement, which is still there in the 1991 Extradition Act in Bahamas, although, as I know the board will know, being dispensed with in many other states, and indeed doesn't obtain between the UK and the US any longer. But there is a requirement that there be a prima facie case established. And then thirdly, there's a third argument that we make, which is set out in our reply at 3.5 at 2234 of the electronic bundle. But I can just show your lordship that by reference to section 7. Section 7(1) D, one can see that there's a provision: a person shall not be extradited under this act to an approved state, or committed to or kept in custody for the purpose of such extradition, if it appears to the minister, to the court of committal, or to the Supreme Court on an application for habeas corpus, and then D, if the offence of which there's A, B, C, and then or if the offence of which that person is accused is statute bar. So it's really what it should read for 7(1) is: a person shall not be extradited. D, if the offence of which that person is accused is statute barred. In other words, there's a prohibition on extradition if the offence is statute barred in the approved state. Now, it is our submission that being a precondition for lawful extradition, the fact that it is not statute barred is something that it is for the requesting state to prove. because one has to read it. A person shall not be extradited, and then there's a series of ors, but the or if the offence of which that person is accused is statute barred. But it should not be statute barred. So we say.
Lord Stevens has a question for you.
I'm so sorry, Mike.
I do apologize. Was that issue ever raised in the Supreme Court or in the Court of Appeal or on the application for leave to appeal to the Privy Council?
I think it is raised, because if you see the Court of Appeal, they set out what the facts are. That I think that's in our case. The need. So if you look at the SFI, my lords, the Court of Appeals. Yes, the affidavit. Yes, if at page 1616 at 2.4, the affidavit sets out the familiarity, her familiarity of the charges and her opinion as to the relevant law. It exhibits the affidavits of witnesses containing evidence given on oath before the grand jury, which result in the indictment, and on which the US relies for its request for extradition. Certifies that the charges of felonies punishable by more than a year's imprisonment. Sets out the warrants of arrest were issued and the dates on which they were issued, and attests that the evidence indicates that each of the appellant is guilty of the offences in the indictment. So it doesn't set out the point about the statute of limitations, but it does recognise that she is necessary to deal with the relevant law. Sorry, my lord. Yes.
There's no reason to think that this has to be proved by the state, is there? These are points that can be raised as a defence to extradition.
Well, my lord,
I mean, you don't have to go through and knock off the points that you would be denied a fair trial and all that sort of thing. And these are points that it's up to the person resisting extradition to raise if they think they've got a ground.
Well, my lord, that depends on the reading, because of 7.1. A person shall not be extradited. So that's an extradition. And then certainly A, B, and C is if it appears to the Minister of the Court of Committal or to the Supreme Court. So that, as it were, you've got to make it appear to them. But then D and E, our reading is a person shall not be extradited. D, if the offence of which is statute barred, and if his extradition is prohibited by any law in force in the Bahamas. So we would respectfully submit that is certainly the D is a precondition.
Suddenly it swings around when you get to D and E. A, B, and C are all points for the person resisting to raise, but then it's up to the state to tick off the limitation point, which normally is a matter for the defendant to raise, isn't it?
Well, my lord, actually, if one looks at it, it's quite clear that if it appears to the Minister of the Court of Appeal, can't apply to A. It can only apply to A, B, and D, because it can't appear to the Court of Committal that the offence is statute barred. So one does have to, as it were, when you're dealing with 7.1D, put a brackets around from the words under to the habeas corpus, and then D if the offence is statute barred.
But it's up to you. If you show it's statute barred, then that will no doubt appear so to the court. If you don't, then it won't.
If it appears so to the court, doesn't govern D. It's in our respect, because it says if it appears to the court A, B, C, and then or, that doesn't.
But they've got or in between them all. They all it's or. They all have to. Any of them has to appear to the court.
Well, but if you read
the sentence, you can't just say read out the words appears to the court for D and E because you don't like them.
Well, no, but my lord, if you try and read the words, if it appears to the Minister, the Court of Committal, or to the Supreme Court on an application for habeas corpus, if the offence of, that doesn't make sense. You wouldn't say it appears to us if the offence is. It would appear to them A, B, and C, but then it's or, and then this is, as it were, not governed by if it appears to. It's governed by a person shall not be extradited if the offence of which that person is accused is statute barred. Well, my lord, that is the submission. We say that's the natural and ordinary meaning of the words.
Mr. Chairman, even if you're right about the language, and I can see purely technically, grammatically, the point you're making.
Thank you, my lord.
Even if 7.1 said a person will not be extradited under this act if the offence of which that person accused is statute barred,
Yeah,
it would still not be something, it's not be something which, as it were, requires the state to prove the negative in its opening case. It would have to be a point to be taken, wouldn't it? It doesn't say the court shall not extradite unless it is satisfied that the offence is not statute barred.
well, my lord, I say it's a precondition of lawful extradition that it be an extradition offence that is not statute barred. Traditionally, and in every single case, this is something that the US deals with, whether it's statute barred or not. In other words, they certainly regard it as something that there's an onus on them to establish, and that's why it's in the recitation of every US attorney that does these recitations. So I say it does actually make sense because they're the people who know whether the offence is an extradition offence and whether it's statute barred. So that's what I respectfully make. My Lord Stephen.
Back to the anterior point. This point, as far as my reading of these papers are concerned, was never raised in front of the magistrate or the Supreme Court or the Court of Appeal or an application for leave to appeal to the Privy Council.
Well, my lord, I'll have to search through the pleadings. It certainly was the question of the extradition offence. Certainly was, my lord. But I don't want to. But
I can find. I'm not saying that I've read every single page.
No. Well, but, my lord.
This is to me a totally novel point, and one that has not been raised before.
Well, my lord, if that is so, I still say it's a good point. But because it's covered by the authentication omission. But I do all I do recall was the Court of Appeals saying what at one point all that Karen Atkinson's affidavit is needed for is to deal with the issues of American law. So I mean, that is one of the issues of American law. And they certainly didn't rely on 5.3. That's a totally novel point raised by my learned friend.
But Mr. Fitzgerald, I mean, it's almost a fantasy to suggest that these offences are statute barred. I mean, there's absolutely no basis for that whatsoever.
Well, my lord, there is the case of ex parte shooter, which I hope the court has received overnight, which basically says, well, that it may well be said that this is a matter of common sense, but actually the things that the state must prove, they must prove, and they must prove by expert evidence. It's positive. Can I just, since obviously,
are you seriously suggesting that these offences are statute barred?
My lord, and that's exactly what was said in ex parte shooter. Can I just take your lordship to ex parte shooter, which was provided. It's ex parte shooter, which was provided overnight.
I think it's been added to our electronic bundles.
Oh, I'm grateful.
But doesn't appear to have been added to mine. But we do have it in a. We do have it in an email sent by the court.
Yes. Well, can I? Yes.
Yes.
Your lordships will see that the point there was whether there was evidence of the law in Kenya, and if I can just take your lordships to page 92, the second full paragraph, and one sees at the end of the second full paragraph, what is said, however, is that there was no evidence before the Chief Magistrate the offences with which he was charged were offences to which the Act applied. And then one sees that there was the question was what was the evidence that was provided was that this was a forgery offence where liable to imprisonment for 3 years, and it sets all those out. And then what happens is that the magistrate sets out, and this is at page 93, at the last sentence, he was setting out the law, and accordingly I have very grave doubts whether the document was admissible under section 29 before the chief magistrate as evidence of the law of Kenya in regard to punishment. Quite apart from this, there is nothing in the order to indicate that the respective periods of imprisonment they referred to are periods of imprisonment with hard labour or periods of imprisonment of such a character as to come within the terms of section 9 for the purpose of rigorous imprisonment, and any shall be deemed to be imprisonment with hard labour. And then at the end, this is really the point made by my Lord Stevens. There's no doubt that this is a technical objection. Is most unlikely looked at as a matter of common sense. Senior resident magistrate in Nairobi would set his hand to such a document as this, as it is inquiry under the Fugitive Offenders Act, without verifying that the offences were offences within that act. It would be, as a matter of common sense, still more extraordinary if in fact these offences of forgery, false pretences and the like were not offences to which the Fugitive Offenders Act applied at all. But be that as it may, the matter must be looked at strictly. And then it cites from the case of Percival, where a similar point was taken, Lord Alverson, Chief Justice, saying, in my opinion, every person who comes and asks for an order, the delivery up of a fugitive offender must be prepared with evidence that that condition of the statute has been fulfilled. That is a very important matter, and having regard to the fact that we are dealing with the criminal law, we must apply the general principles of the criminal law. The prosecutor must make out his case. We are dealing also with a branch of the criminal law which affects the liberty of the subject, and that condition should under ordinary circumstances be clearly fulfilled. That view was expressed directly in regard to the calling of the evidence as to the local law. I incline to the view, as I have said, that there was no evidence at all for the Chief Magistrate as to the law in regard to punishment, and in any event no evidence the offences came within section 9. But whether I am right or wrong, I feel very strongly that in these cases there should be a settled practice, and that in every case an expert on the local law should give evidence, either in the form of a deposition which comes over with a warrant, or orally before the Chief Magistrate in this country. So far as the present case is concerned, I think that the proper course is to remit the matter to the Chief Magistrate in order that it be dealt with in accordance with what I hope will become the settled practice. So, my Lord, I know it's not a total answer, but I do respectfully submit that to the point, well, it's blindingly obvious that these are extradition offences and blindingly obvious there's no statute of limitations. Yes. Oh, yes. My Lord, my learned friend, Mr. Middleton's just pointed out that our submissions in the Court of Appeal do say that that Catherine Atkinson dealt with the law, including limitation, and that's in the electronic bundle at 1429 to 1430, paragraph 8.14. I mean, it was the Court of Appeal recognised, rightly or wrongly, or proceeded on the basis she was necessary to establish the points of American law which needed to be established for the treaty and the act. And so, my Lord, my learned friend's point about 5.3 was not taken below, and my learned friend's point about how the affidavits were in any event certified by Karen Atkinson in the last part of her affidavit was not taken below. Everything hinged on, is Karen Atkinson properly certified by Lister Blake? Yeah, my Lord.
As I read it, the point about the affidavit being certified by Karen Atkinson was made by the judge in the Supreme Court.
By
the Supreme Court.
Oh, it was the point about the affidavits being certified.
Yes, that they were evidence that was certified by Karen Atkinson.
Well, my Lord,
which on the face of it seems obviously correct.
Well, my Lord,
do you accept it anyway, that is the case?
Well, my Lord, what we accept is that she says, I certify those things. The question, the only point we have in relation to that, and I agree it's a narrow and technical point, is that if her affidavit was not properly certified, then the affidavit as a whole and all its contents were not properly before the court. That's our simple point. It's true that in the context of it, in the second part of it, if I can call it that, right at the end, she says, "I certify these." But if our first point is correct, that's to say that if her affidavit as a whole, because it's not certified, is inadmissible, then none of it is properly before the court.
But does it say, does the legislation require that the evidence be certified in an affidavit which is itself authenticated? I mean, how many layers do go on applying that? It doesn't, does it?
No, your lordship is right about that. That's correct. The only question is, if Karen Atkinson's affidavit isn't well, if it's not properly certified, then the evidence contained within it as to law would be inadmissible.
I understand that point. I'm just trying to get clear whether you actually say that it knocks out the whole of the evidence in the exhibits as well.
I do, my lord, but that's my submission. But if I can respectfully put it, I understand your lordship's point point that's troubling, if I can put it that way.
Thank you.
Could I respectfully then move on to section 14? So section 14 itself, if we look at that in the Act, 14.1, in any at page 1727. In any proceedings under this Act, including proceedings on an application for habeas corpus in respect of a person in custody under this Act, a document duly authenticated, which purports to set out testimony given on oath in an approved state, shall be admissible as evidence of the matter stated therein. So that's the Karen Atkinson is only admissible, certainly insofar as it purports to set out testimony given on oath, if it's properly duly authenticated. And then the test of duly authenticated is set out at section 14, subsection 3, over the page at EB 1728. A document shall be deemed to be duly authenticated for the purpose of this section. A, in the case of a document which purports to set out testimony given as referred to in subsection 1A, if the document purports to be certified by a judge, magistrate, or officer of the court in or of the approved state in question, or an officer of the diplomatic or consular service of that state, to be the original document containing or recording the testimony. And I know that the board has our point that we say that there is nothing to indicate that Lister Blake purports to be either a judge, magistrate, or officer of the court in her statement. And therefore, we say that to the extent that she is relied on for authentication, she does not provide it. Can I just indicate that there are additional requirements which are in the, if I can call it the part 2 of subsection 3, where it says, and in any such case, the document is authenticated either by the oath of a witness or by the official seal of a minister of the approved state in question. So to the extent that my learned friend appears to be relying at times in his submissions on authentication by a seal as somehow saving the day, we respectfully submit that's an additional requirement. Yes, my lord.
If I can take you back to the beginning of 14 subsection 1.
Yeah.
And that is the these proceedings before us would be proceedings in relation to an application for habeas corpus.
Yes.
So are we in a position to admit further evidence? Because the respondents refer to a link which establishes Blake's qualifications as an attorney. So your case, as I understand it, is she didn't purport to be an attorney, but in fact, in reality, she may very well be an attorney. And so can we not just rely upon that?
Well, if you, my lord, we would say that the committal was invalid because this requirement was not made out. What seems to have happened in the Shooter case was it was remitted back for the matter to be, as it were, remedied at a fresh hearing. So
why would we do that if in fact she is an attorney?
Well, my lord, at present there is no I'm so sorry, my lord. At present there is no application before the court to adduce further evidence. But if there is, we would obviously resist it on the basis it's too late. But my lord, that's our respectful submission. But I mean, in Shooter, what they did was to remit it, and as it were, and say, as it were, start again, where the evidence was.
To take a more drastic approach, what's to prevent the United States from issuing a new certificate?
You mean if we start again? Well, they might. You mean? Well,
no, they're not necessarily starting the whole proceedings again, but issuing a certificate
before the board.
Yes.
Yes.
Well, my lord, that would be subject to new evidence being admitted. Yes, I mean, but there's no application to admit new evidence. But my lord, I would obviously say too late. But if my learned friend makes the application, which he hasn't yet made, I will deal with it.
Yep.
And what's the position then, Mr. Fitzgerald, if he undertakes to provide that evidence?
Well, your lordships would then have to consider whether to admit it.
Yeah.
And I would object. But I mean, my lord.
Well, I can
well,
see that you
my lord,
object.
I'm grateful. Sorry. I'm grateful to your lordship for indicating that the board is now going to take a relaxed view on the admission of evidence at the third stage, because sometimes it's been difficult, and there's a series of tests laid down in Benedetto as to what has to be satisfied before new evidence is admitted at the board, and notice being given, explanation of why it wasn't done before, etc. But if the board takes the view that the test laid down in Benedetto could be satisfied, my lord, as it were, bring it on, and I will oppose it. But I'm sorry, I'm not being flippant, my lord. I'm just saying that there are rules. Yes. Yes, and my lord, can I then just go on to the position then on the position under 14.3a? It is our respect.
Mr. Fitzgerald, Lord Briggs has a question.
I'm so sorry, my lord.
Just before we get into 3a, do you say that the requirement that the document, well, the statement that the document shall be deemed to be duly authenticated is exclusive? Or is it simply that this is, without prejudice to other ways of due authentication, sufficient for the purposes of the Act?
My lord, I say that is the only mechanism for due authentication laid down in the Act, and that it must be complied with, my lord. Yes.
What about subsection 6, Mr. Fitzgerald?
Well, what I submit about that is that that really relates to something different, which is for example, very often in order to admit evidence, sometimes evidence has to be admitted in habeas corpus proceedings from, say, the police in the requested state, say the Bahamas, and you have evidence from the police officer in Bahamas, which would therefore can be admitted very often, for example, if you're dealing with a passage of time problem, there is evidence from within the requested state, i.e. the Bahamas in this case, from a police officer or a witness statement taken from within, and that's to ensure that that evidence can be admitted, prevent the proof of any matter in accordance with any other law of the Bahamas. So that is the function, not to exclude evidence that doesn't necessarily come from the foreign state, but may come from the requested state itself. And that very often happens. You have a Section 9 statement, or you have oral evidence given by an officer in the requested state. So that is, in my respectful submission, the function of 14.6.
Doesn't 14.6 indicate that the procedures that we're looking at, particularly in 14.3, are additional to the normal ways of proving something?
Well, my lord, that is not the way it has been. Sorry, it's certainly not the way it's been interpreted hitherto. That you can prove it any other way you want, it's quite true that the words duly authenticated in 14.1a don't say in the manner laid down in 14.3. So I accept that point. But we say that this is supposed to be a code for the admission of evidence provided by the requesting state, and that 14.6 has a different explanation, which is that very often evidence needs to be admitted from witnesses who are in the requested state, and that would just be governed by the normal evidentiary rules that apply in that state.
Thank you.
My lord, my respectful submission is that the 14.3, the deemed, that is the test. But we certainly that was what has, again, the reality of this case is that what has been relied on principally is, well, she is within the test, if one gives it a broad definition. And my learned friend, certainly until we received the case, in the objections was sustaining the point that she was in fact within the test in 14.3a.
Thank you.
My lord, obviously, whatever the outcome of this particular case, it's clear that this test has been interpreted and applied in Jamaica also in one of the cases, and that this formulation, judge, magistrate, or officer of the court, which is different from that under the 1870 Act, which was judge, magistrate, or officer of the state, is being used in the Caribbean. So we would respectfully submit, I assume that's why the leave was granted, that this is a point of some importance to resolve. And well, I think the board probably has therefore 14.1 and 14.3a, and the fact that the and in 14.3 is relating to the seal is an additional requirement rather than a substitute. Then, if I can just look at the documents in the case briefly, my lords. If we start with the document of Colin Powell, that's in the electronic bundle at page 30. Does the board have that? I certify that the document hereunto annexed is under the seal of the Department of Justice of the United States of America, and that such a seal is entitled to full faith and credit, in testimony whereof I, Colin Powell, Secretary of State, have affixed the seal. And some of the old cases had things about whether if the ribbon had to go through all the affidavits. We're not taking that kind of point. To your lordship's surprise, no doubt. but that has been disposed of. So that's the first of the documents. And when my learned friend and I consulted as to why one has that and then another Department of State over the page at page 31, I think really the answer is that's just the way they've always done it. But obviously we take no point on that. But if one looks at over the page, you have the Attorney General, who is Mr. Ashcroft, and he also affixes a seal, which we're content to take that it applies to all the following documents. Whom these present shall come greeting, I certify that Lystra Blake, whose name is signed in the accompanying paper, is now and was at the time of signing the same as Associate Director, Office of International Affairs, Criminal Division, and then duly commissioned and qualified. So we say that is not an assertion that she is an officer of the court, but just that she's duly commissioned and qualified as Director of the Office of International Affairs. And that then provides, that deals with, as it were, part 2 of 14.3, where you've got to have, and in any such case, the official seal of a minister. But it doesn't substitute, we say, for 14.3a. And then we get to the key document, the certification. I, Lystra Blake, Associate Director, Office of International Affairs, Criminal Division, United States, do hereby certify that attached hereto and prepared in support of the US request for the extradition of Austin Knowles, aka Ozzy, is the original affidavit of Karen Atkinson, Assistant United States Attorney for the Southern District of Florida, sworn to on January 29, 2003, before United States Magistrate Judge Vitunak, with attachments. Now, we accept that is a certificate, but we just simply say that she does not purport, as required by 14.3a, to be a magistrate, sorry, a judge, magistrate, or officer of the court. And we say that is fatal to her certifying the affidavit of Karen Atkinson, which follows. And that, my lords, there are 2 parts to that. We say, firstly, it's fatal to her certifying it in such a way as to provide due authentication for the purposes of 14.1a, giving evidence on oath. And to the extent that in that sworn testimony, she also certifies the affidavits that are exhibited to it, we say that the document is not duly authenticated in that way. And so we say that Karen Atkinson, insofar as she gives evidence, expert evidence of foreign law, is inadmissible for failure to comply with the requirements of 14.3a. And insofar as in that sworn affidavit, she exhibits, as part of her affidavit, the statements of the witnesses relied on for a prima facie case, we say it's also inadmissible for failure to comply with 14.3a. That's in essence our respectful submission to the court. Then all we really have to deal with then, and this is set out at paragraph 7 of the case, is the fact of what she provides. The first thing we'd say is that her affidavit contains expert evidence as to US law, and in particular as to the penalties for the alleged offence. This was necessary in order to establish the extradition offence. So that should be 5.1, as your lordship pointed out to us.
Sorry, Mr. Fitzgerald, you turned away from the mic.
I'm so sorry. I'm so sorry. That's necessary to comply with 5.1b, but it's also necessary to comply with the extradition treaty, which you have the treaty at Article 8, which is at page EB 1743, and one sees there the state that the request shall be supported by documents, statements, or other evidence which describe the identity. B, a statement of the facts of the case. C, a statement of the provisions of law describing the essential elements of the offence. A statement of the provisions of law describing the punishment of the offence. And E, a statement of the provisions of law describing any time limit on the prosecution. So those are mandatory requirements under the treaty. And 5.1b.
Before you move on, I think Lord Leggett's got a question on that.
I'm so sorry, my lord. Yes.
Does it matter for present purposes what the treaty says? I mean, is it a requirement of the Act that you have, in addition, to have complied with the treaty if it's a separate article?
Yeah.
Under normal principles, the treaty wouldn't be part of Bahamas law.
Yes. Well, my lord, it's really section 5.1b1.
I understand that point. I'm just trying to work out whether your point about the treaty carries any weight. I can't see at the moment that it does.
Well, my lord, there are, to the extent that 5.1b1 says it is an offence which is provided for by the extradition treaty, you then therefore need to have something which says that it is provided for by the treaty. And the treaty provides that it's where is it? Article 2 of the treaty, my lord. An offence, Article 2, extraditable offences at page 1738. 1, Article 2.1. An offence shall be an extraditable offence if it is punishable under the laws in both contracting states by deprivation of liberty for a period of more than 1 year. So to that extent, provided for by the treaty, that's incorporated into the Act, that requirement.
Right.
But my lord, it's probably not the case to deal with the vexed issue of what the status of the treaty is, if and insofar it's not incorporated into the Act. But that requirement is incorporated into the Act.
Yeah, thank you very much.
But what we do respectfully submit is that the Article 8 does underline that this is a mandatory requirement. That it can throw light on the importance of the requirement in the Act, that it's a mandatory, it shall be supported by those. And your lordships will also observe at page 1745, Article 8, sub-article 6, documents in support of the request for extradition shall be transmitted through the diplomatic channel and shall be admissible in extradition proceedings if certified or authenticated in such manner as may be required by the law in the requested state. I mean, that leads us back to the authentication issue. I accept it doesn't solve it, but it shows the important. It perhaps indicates that this is a mandatory requirement. So that's our first point, is that there does have to be expert opinion, that it carries more than 1 year, and subject to the points that have been put to me by my lords, we also say that she provides expert opinion as to the fact that the prosecution is not time barred, and she deals with that at Karen Atkinson at paragraph 19, and we say that that was necessary in order to establish that there was no restriction on extradition under section 7.1d, and also to comply with article 8.2e of the treaty, a provision of the provisions of law describing any time limits on the prosecution at EB 1743. My lords, on the question of section 5.3, we I think I've really made my best run at it, if I can put it in that respectful way. But we do deal with that in the reply at EB 2234, and that's at 3.4. Karen Atkinson's affidavit, we say, was also necessary to establish the crimes were extradition offences by evidence as to the nature of the crimes and the penalties that they bore. Contrary to the respondents' submissions, the deeming provisions of 5.3 did not apply, so as to deem the alleged crimes to be extradition offences. That's because the minister failed to certify, as required by 5.3, that the request was received from an approved state for the purpose of Section 8. This is clear from the express terms of the authorities to proceed. So, subject, obviously, we wrote that before my Lord Stevens's, as it were, points were put to me. But that is essentially our response. But does my Lord Briggs have an issue? Oh, sorry, sorry. Yes, sorry. So those are our submissions that she was necessary. Then, as to the fact that she exhibits statements to establish a prima facie case, she exhibits the statements necessary to establish a prima facie case. And we've got that in her affidavit. She deals with, if we go to the, you can see at paragraphs 18 and 19, she deals with the sentence so as to comply with the treaty. That's more than 1 year. She
Page
deals
is that, please?
It's EB 42, my lord.
Thank you.
So paragraph 18, she says that a violation of any of the above statutes was and is currently a felony under the United States law, punishable by more than 1 year imprisonment. So that deals with the point at article 2. And then 19, the statute of limitations on prosecuting these offences is prescribed by Title 18, is within 5 years. Therefore, the charges, the last sentence, are filed within the prescribed time limit. And then it's then at conclusion, at page 44, my lords, one has, I've attached to this affidavit the affidavits of witnesses providing testimony to establish proof of Austin Knowles' criminal activities in violation of the laws of the United States of America, as alleged in the superseding. All of the affidavits were sworn in my presence before United States Magistrate Judge Vitunak, who is legally authorized to administer an oath for this purpose. And one has, and then, so that's, she deals with that. And then at the very end, one has the passage that my learned friend relies on and that my lords have put to me under the heading attachments at page 52 at the bottom. Attachments. As an officer of the court, I certify the attached hereto are the following exhibits in support of extradition. And then she sets out the various provisions of United States law and the statute of limitations, and then the various affidavits of special agents and witnesses, including, I think, cooperating witnesses, Mellor at the end. And then Kurt McBride. So, my lords, again, on that, our point is a limited one, but it is simply that if Karen Atkinson's affidavit is not properly authenticated, then we say the whole of it is inadmissible, and that includes that part of it which exhibits, because she says the following exhibits at pages 52 to 54, and that is our submission. So,
Mr. Fitzgerald, at the moment, I don't understand why Karen Atkinson's affidavit needs to be authenticated.
Well, it needs to be authenticated, my lord, because it's got to be duly authenticated according to 14.1 41A, insofar as it purports to set out her evidence, which then becomes evidence before the court. So if one goes back to 14.1a, my lord.
But why does Karen Atkinson's affidavit not stand itself as a certification? First of all, of the affidavits that it produces.
Yes.
And secondly, why is it not a certification of the printed copies of the US statutes which relate to penalty and limitation?
Well, my lord, because they have to be proved by expert evidence. We say see shooter on that in that regard. You can't just put I mean, that was exactly the point made in shooter. You can't just, as it were, put a statute. You don't know whether the statute's in force or up to date until such time as you have an expert telling you that it is. That's the point that was made by the divisional court.
But she's an officer of the court.
My lord, can I say this? To the extent that she provides expert evidence of foreign law, it's our submission that she is covered by 14.1a. That's to say, this is a document, her statement, purporting to set out her testimony given on oath. And that's the testimony given on oath is her expert evidence to comply with the shooter requirement. So that's why we say that has to be authenticated. To the extent that at the very end there is her saying, I certify the attached. My lord, I do accept that that's a different issue, but there I respectfully submit that her certification and her exhibiting of the affidavits is all part of this document. I mean, she does it in the course of a sworn affidavit. So, my lord, I accept it's a different point, and it may not be as forceful a point, but in relation to that, I say the exercise of exhibiting these affidavits is an exercise carried out in the course of sworn testimony to which 14.1a applies, and therefore it isn't, as it were, it isn't a freestanding certificate like Lister Blake's purports to be. My lord, that's the submission.
Right. Thank you.
My lords, those then are the basic submissions we make in relation to that. I think if I can just go to the back of the case, just to see that the relevant points. You have, if we can go to the case under the legal framework at page 1633, you have there the provisions of section 10.5 set out at paragraph 11, and the admissibility test is set out at paragraphs 13, 14, which I've now taken the court to. I think the court does have the 1870 Act now and section 15 of that. So if you're looking at EB 1634, where it says 14.3a, if the document purports to be certified by judge, magistrate, or officer of the court, you can perhaps contrast that to the provisions of section 15 of the 1870 Act, where it was section 15.1. It's authenticated as follows: if the warrant purports to be signed by a judge, magistrate, or officer of the foreign state. And so one can see that there is a change from judge, magistrate, or officer of the foreign state in the 1870 Act. And my learned friend has also provided you with the 1967 Fugitive Offenders Act. And can I just give you, for the sake of completeness, in section 11(2)(a), the same formulation of judge, magistrate, or officer in or of the country was there. So what appears to have happened is that that has been changed from judge, magistrate, or officer of the country to judge, magistrate, or officer of the court. And that change has also been replicated in the Jamaican legislation, their 1991 Act, which the court has in the case of Ramcharan, which is at tab 22. Sorry, and that's at EB page 2038. So one can see at page EB 2038, the section 14(1)(a) in the Jamaican Extradition Act talks about judge, magistrate, or officer of the court. So there's been a change, both in Bahamas, and we now know from Ramcharan in Jamaica, from judge, magistrate, or officer of the state to judge, magistrate, or officer of the court. And we say that that is a significant change, and that she never purports, Karen Atkinson, to be an officer of the court. And it's not a question, in our respectful submission, of what she is. It's a question of what, in the document producing this this evidence, she purports to be. And that's why it would be necessary for her to, as it were, do the exercise again. Sorry, my lord, yes.
Can we take a purposive view about why purport is used here?
Yes.
I'm going to put to you a purposive view, just as it were off the cuff, and see what you make of it.
Yes.
The reason it says purport is so that, providing that's what it asserts on its face, you can't go behind it.
Yes.
But why should that mean that if it doesn't purport, but we know that it's true, that should be ineffective? I accept it may have to comply with some other rule of Bahamian evidence, that the knowledge that it's true. But surely the purpose of having purport is to put the underlying truth of what something purports to say beyond challenge. But if it's beyond challenge anyway, why should it matter whether it purports or not?
Well, my lord, I'm sure you're right that the reason why it purports is that all that has to be done is that the person in the requesting state purports to be that, and then you assume that they are. But if you don't even purport to be, you haven't got stage one. Is our respectful submission. I mean, if you purport to be, then subject to bad faith, which might lead to some invalidation, that would be the end of it. But my lord, there's nothing to say that it's admissible if it's authenticated by someone who neither purports to be nor does evidence show is a judge, magistrate, or officer. And the point is, this just wasn't dealt with in the documents that were provided to the court. Sorry, my lord, Lord Lee.
Does it make any difference that no objection was raised at the time? I mean, why should you be allowed to raise this subsequently if the evidence was admitted without objection?
Well, my lord,
on
because
on this ground,
if it goes to jurisdiction, then I would, if it goes to the admissibility of the evidence on which the extradition is founded, then, my lord, I would respectfully submit that the point can be properly taken on habeas corpus. It was taken in the Supreme Court, And that's to say in our equivalent of the High Court in Bahamas.
Yes, I can't actually see it was in your notice of motion for the habeas corpus, despite the fact there were 17 points there, but it wasn't one of them.
There was a subsequent thing, but you can actually see them responding to it in writing on the 3rd of March.
Well, it may have been maybe they did deal with it in the Supreme Court, but why wasn't it waived by the failure, by the fact that your clients didn't take any objection on this ground?
You mean in the magistrates' court?
Yes, in the magistrates' court, when it was put in evidence for the magistrate.
Well, my lord, my simple response to that is you can't waive an issue of law. I mean, if there is a procedural defect, there's a procedural defect.
Well, normally there's a distinction between some which you know procedural defects which you can waive and some that you can't. And I just would have thought there'd be some law about this, but maybe the point's not being taken against you.
Not yet, my lord, but
right.
But I obviously await developments. But my lord, I think my learned friend does say that he does. Yes, my learned friend does say this point was not taken, and if it was taken, it could have been addressed. So to that extent, but the point is that it was argued out both at the Supreme Court and the Court of Appeal without the other side saying, "Well, just hang on a moment, we'll fix this." You know, so I think it can cut both ways.
Yeah, the waiver was waived.
Yes, exactly. Yes, yeah. They didn't say. Oh, if only you had pointed this out in the magistrates' court, we would have. And now let us put it right. For years, the case has proceeded on the basis that 43A is. Those. Sorry, what we do. We set out. Can I just try to assist the board very briefly by what else we've got in the case? From paragraphs 18 onwards at page 1636, we've set out why we set out that we say it's mandatory, and we've cited Oscar and Ramcharan. Ramcharan didn't, the Jamaican case at paragraph 20 didn't deal with this particular issue about Listra Blake. But it did recognise that the requirement was mandatory, and that's at 2039B. And then we've dealt with the fact that at page 1637, at paragraph 22, the evidence relied on was provided by Miss Atkinson's affidavits, and that's an agreed fact. And we've referred to the summary provided by the Court of Appeal, which is at EB 1519. We've dealt with the issue of purporting to be, and at paragraph 25, the 5th point, it must be certified as an original copy of the true copy by someone who purports to be one of the persons listed in 14.3. And then we say that the only person who purports to certify Ms. Atkinson's affidavit is Listra Blake, and then you have our submissions at paragraphs 27 and 28. As to she doesn't purport to hold any of the offices listed in 14.3a, judge, magistrate, or officer of the court, and it was only Listra Blake who purported to certify Miss Atkinson's affidavit as an original or true copy. Now we then go through, and my lord, just before the break, can I just indicate we go through a series of the points that the Court of Appeal made and seek to indicate that they're not valid ones. I could probably do that in 5 minutes and then break if your lordships would find that helpful.
Yes, very well.
Yes. So at paragraph 31, firstly, the Court of Appeal held that Listra Blake described herself as associate director, and they say that the sense, tenor, and apparent meaning of that certification is the affidavit purports to be certified. But we say, with respect, that doesn't deal with the point that she doesn't purport to be one of the office holders who can legitimately certify. Secondly, the court relied on the US Attorney General's certificate that she was duly commissioned and qualified. We say that that doesn't answer the problem because she was duly commissioned and qualified as Associate Director of the Office of International Affairs, and we set that out at paragraph 34. It doesn't say, imply that she was also a judge or magistrate or officer of the court. Thirdly, over the page, they at paragraph 35, they rely on the dictionary definitions of purport. We say those really don't assist. And in any event, she's got to comply with the requirement that she purports to be one of those people. As my Lord Briggs has pointed out, if she does purport to be, then you don't look behind that, save in an exception of a case of bad faith. And then paragraph 37, fourthly, the court relied on the presumption that officially executed acts are presumed to be valid unless the contrary is shown. We really submit that at paragraph 39, that this is a shooter type case where Parliament has enacted a specific and mandatory requirement in extradition proceedings that can't be displaced by some general presumption. No presumption can override the express statutory requirement. We also submit that the fact that Lister Blake purports to be one of the persons specified, the fact the US government must prove in order to rely on her evidence, the burden of proof is on them. See in that respect, shooter, that they've got to make out the necessary pre-requirements. Then if I can take the board on to paragraph 43, fifthly, the Court of Appeal noted that the appellants had focused on the capacity in which Lister Blake has stated she was acting, not on whether she was in fact. But we submit, they say, notorious fact that she was a person authorised to certify the usual affidavit. Well, there does seem to be some confusion because it may well be that they thought, well, she's an officer of the state, and officers of the state generally in UK type requirements are enough, so that you wouldn't need to go on to deal with the question of whether she's an officer of the court. And then finally, the sixth point the Court of Appeal make is that the Parliament cannot have intended a bare technical point. That's at paragraph 46 of our submissions. We say it's not that she forgot to mention it, but that it was not a capacity that she purported to be. It's not a bare technical point, and really on that we do submit that the whole approach of the Divisional Court in Shooter in 1960 indicates that the requirements of the law must be gone through. Then the court also, this is at paragraph 48, relied on the 14.6, but we say there can't be an onus on us to prove a negative. This is at paragraph 49, to go for every provision of Bahamian law and say they don't apply. And in fact, there's a much easier explanation of why 40 there, which I've sought to give to the board. And then you have our submission on my learned friend's approach to the authentication point. In the observations made on leave, where it was rather tortured construction was put forward, officer, quote, officer, comma, of the court in or of, comma, the approved state. We say that that just doesn't work. We know exactly how you put it when you mean judge, magistrate, or officer of the state, because that was the way it was put in the 1870 Act and the 1967 Act, and it just simply says judge, magistrate, or officer of the state. It's changed to judge, magistrate, or officer of the court, and we submit that some significance has to be attributed to that, and the plain words just don't fit, saying, well, she's an officer of the state, so that's okay. My lords, would that be an appropriate moment to break for 5 minutes?
Yes, thank you, Mr. Fitzgerald. We'll take 5 minutes. Thank you. Mr. Fitzgerald.
Yes. My lord, those are really our submissions. Other points are set out in our reply. We do respectfully make the point that just in respect of the affidavit, insofar as it produces as exhibits the various statements, that the exhibits are effectively incorporated into the affidavit, and therefore on that basis we would submit that they are, if the affidavit is inadmissible, so too are the exhibits. But I think I've made that point, and we do just draw your attention to the cases which we cite in our reply at 3.2, the cases of Chetter and Hinchliffe, where they say that the exhibits are, as it were, to be treated as if they're set out in the affidavit, an integral part of the affidavit, as it to be treated as copied out in the text of the affidavit. That's at page 2233. I think all the other points I have in one way or another set out in our reply, I have in one way or another dealt with. And to the extent that we rely on non-compliance with the treaty, can I just indicate that where the treaty definition of an extradition crime is incorporated into the Act, then clearly it becomes part of the requirements of domestic law. But to the extent that the treaty, and secondly, to the extent that the treaty underlines the importance of having all the materials set out in Article 8, that also underlines the importance of observing the requirement that domestic law, that American law be set out in the request properly, in an authenticated manner. But I don't say in these proceedings that the treaty obligations themselves add any additional point other than where they're incorporated. So my lords, I hope that makes that clear. And I know that my Lord Legate put to me issues on that. That leaves, my lords, the ground 2, which we've dealt with at pages 1648 onwards. That's to say the delay. And I think it may assist if I just summarise.
Before you move on, Mr. Fitzgerald, there's a question.
Sorry,
Mr. Fitzgerald. There was just one issue I'm not certain that you have covered, certainly orally, and that is the respondent's argument at paragraph 37 at page 1665, which relies upon the admission of the United States laws under section 14(1)(b).
Oh, so sorry, my lord. Under section 14(1)(b).
Yeah.
Yes. Yes. Well, but we would say that the laws need to be. You mean that can just producing a section of the Act?
But insofar as I understand the argument, at paragraph 36, the sections, the relevant parts of the US laws were referred to in the affidavit of Karen Atkinson, but they were received by the United States Magistrate Judge in the United States of America. And that would bring it in within 14(1)(b).
Well, what I don't quite understand is what are the proceedings in the approved state, because the proceedings, I mean, that might well be if somebody gave evidence in the United States and you had a transcript of their evidence, that would be covered by 14(1)(b), which often does happen. But it's not as if there have been any proceedings in relation to these applicants in relation to which those documents were received. So that what we say is that there have been no proceedings in the approved state. The proceedings are in the Bahamas, and so what 14(1)(b) deals with is where there's evidence that was where there's a statement that was received in evidence in the course of a trial or committal proceedings in the requesting state.
Mr. Fitzgerald, if we look at page 33 of the bundle,
yes,
it does appear that Karen Atkinson's affidavit does bear the heading showing that the United States District Court, Southern District of Florida, and that the statement is made in the matter of the extradition of Austin, Knowles, and others.
well, that's right. That's the heading, but we do deal with this in our reply. We say that mere heading doesn't mean that whether we're proceeding. These were documents prepared exclusively for the extradition. There wasn't a hearing there. I think we do deal with this point. I'm so sorry, my lord. If I can just find where we address this issue in. Yes, at 3.3 on page 2233, they put forward an alternative argument 36 to 37, because each document duly authenticated purports to have been received in evidence. Existence of such proceedings is said to be established by the fact that the witnesses' affidavits submitted in these extra are contained in documents with the heading United States District Court with a case number. But we submit there's no basis for saying these affidavits have been received in evidence in the US District Court, nor do they purport to have been received in evidence in any proceedings before the US Court. They've been prepared for the purpose of these proceedings. The mere heading doesn't get you anywhere. All you've got is that it's been sworn before a judge, and that's Vitunic. But there aren't any proceedings. I mean, what this is meant to deal with is if somebody's given actual evidence or produced documents in an actual hearing, very often the co-accused has been dealt with or something like that in the requested state. But we respectfully submit that those words in 14(1)(b) are not apt to cover the situation of just putting in a statute. My lord, that's how we answer that point, my learned friend.
And if the deeming provisions are no more, no less than that, deeming, so that you can duly authenticate in some other way, then the judge has authenticated duly authenticated those particular provisions of United States law. She subscribed to the affidavit.
Well, yes, the Judge Vitunic certainly signed. She witnessed the affidavit. I accept that.
She subscribed to and swore the affidavit. Yeah.
Yes, my lord. I do accept. Yes, yes, my lord.
So there were proceedings before the grand jury. Are those different proceedings? Those referred to in Atkinson's affidavit?
I think they would be different. Yes, because they would be closed. I think yes. They wouldn't. Yes. This just appears to be. I mean, to call them proceedings seems to be a rather grandiose expression for a statement was made before the magistrate for the purposes of this extradition. I see my learned friend shaking his head. No doubt, he'll put me right if I've got that wrong. But that's my understanding, and that's how we've presented the position at 3.3.
Well, certainly a convention-compliant proceedings would start potentially with the issue of the warrant or the issue of the grand jury proceedings, and
yes,
and they would encompass all the proceedings.
Well, my lord, what I do accept is that there would have been grand jury proceedings, but I'm not sure that the tunic that was my understanding. That was expressly for the purposes of this extradition, that they went and took a statement before her. Well, my lords, that can I just very briefly deal with the further point, and my lords, I accept that really what the Court of Appeal said was it's your duty to get on with your habeas corpus, and you can't complain that it hasn't been heard within a reasonable time if you can't produce evidence that you're pressing for it, as it were, to be proceeded. Now, what we respect, can I just do it in a kind of compendious way? What we respectfully submit is the extradition proceedings have to be seen as a whole, and they're proceedings brought by the requesting state. The habeas corpus is obviously a right of the appellant to challenge those proceedings, but it's part of an overall set of proceedings initiated by the requesting state. And the Court of Appeal itself accepted, and I think we've said that out in the case at paragraph 75, at page 1652 of the electronic bundle. And that is ultimately the duty of the requesting state, with the assistance of the requested state, to pursue the extradition. And then, but they didn't reflect that important statement of principle. My lords, if one actually goes to the chronology very briefly, which is at pages 1626, 1627 of the bundle, the agreed chronology, one can see, yes, one can see there 1626 to 1627. If we go back down to the bottom of page 1625, after there's the magistrate's committal, you can see at 2004 there's the order of the registrar to deliver a copy of the transcripts exhibits, and what the magistrate provided was copies of the rough transcripts. So in fact there never was a certified copy of the transcript provided. But just setting that aside for the moment, if the board looks at page 1626, 2008, there is the mention of the habeas corpus proceedings, which, as it were, resume after the interlude of the application to the to your lordship's board the first time round. The case is mentioned, and the Judge Allen makes an oral order for the register to produce the copy of the so that would be a certified copy of the transcripts and exhibits, and then, as it were, the question of the certified copy goes into abeyance. It's never produced, and indeed in the end we simply got on with what were called the rough copy, and you can see that at the bottom of each of the pages it says rough, look for example at EB 278 and you'll see the word rough at the bottom, because that's as good as it got. But what happens is that from 2008 onwards, there is no progress in the case until 2015, irrespective of this issue of the record. And you can see that in 2010, Mr. Braithwaite, Chief Counsel in the Office of the Attorney General, writes the appellants for dates of his availability, which he provides, because then he writes in July 2010, Mr. Braithwaite, this is top of page 1627, saying that Mr. Gomez has indicated his availability. So the appellants and indeed the respondent were ready to go ahead then, irrespective of the record. And you see that then from there onwards, so from 2008 until 2015, there is this correspondence in which there's no question of there being any non-compliance or non-cooperation by the appellants until 2015. Now, we do respectfully submit that the jurisprudence of your Lordship's board in relation to the death penalty, you don't have to hasten on your own fate as long as you're not objecting to it and you're cooperating with it. So it's the duty, as the Court of Appeal recognised, of the requesting state and indeed the courts to progress it swiftly. And therefore, to some extent, this dispute about whether there was a rough copy or the finalised version is a bit of a red herring, because if you look at that gap between 2008 and 2015, nothing happened because of what the prosecuting counsel, Mr. Braithwaite, described as judicial inertia. It's true that then there's a new team involved, because I think Mr. Gomez had held a position in the government. You see that in 2015, it's Mr. Elliot Lockhart dealing with it. And in May 2015, and he's asking, they're saying we still haven't received the transcripts. And it's clear that what's being referred to there is the formal transcripts. Well, in fact, they were never produced, the formal transcripts. Now, it may be said, well, why not just get on with the rough transcripts, which was what was done in the end anyway. But this is a small part of the delay, the total delay from 2015 in May to 2016, where the judgment is given, where there was, it's right, an insistence, well, we want to have the certified transcripts, which in the end were never got, and what they had, which was all they had all along, was the rough copies. So I do respectfully submit that there is a very long delay in determining these issues, that the duty was on the requesting state and indeed the courts for this matter to be progressed with reasonable speed, that it's true that the appellants weren't saying, please hear our case. And to that extent, where they're complaining of the breach of a constitutional right, I accept that that can be taken into account. But at the end of the day, we say that that part of the overall extradition proceedings, which involved the determination of their civil right or obligation to remain in their country, as recognized in the case of Pomachowski, was not decided within a reasonable time, and that was a breach of their constitutional rights. And
Mr. Fitzgerald, doesn't this question of passage of time have to be addressed in the context of the specific provisions of the Extradition Act? Isn't there lex specialis?
Oh dear, not lex specialis.
I'm not allowed to say that. Aren't these particular provisions,
my lord,
in priority.
I understand. Well, my lord, I say in that, I mean, what I do accept is that if your lordships look at the case of Fuller, that there the board, in relation to a similar lapse of time type argument, took the view that, well, you can't complain if you haven't been pressing for the case to be, you can't complain of lapse of time in that respect if you weren't pushing for your case to be heard swiftly. I mean, as it were, if you're colluding in the delay. But my lord, in relation,
my point was a rather different one, and that is that here the point was run in the Court of Appeal that it would be unjust or oppressive to return these alleged offenders because of the passage of time. A familiar plea in extradition cases dealt with variously by different statutes. That argument was run unsuccessfully. There's no appeal in relation to that decision, in relation to the provisions of the Extradition Act governing passage of time. Is it really open to the appellants to raise these issues dealing more generally with the passage of time under the Constitution?
well, that would depend on whether they're a coextensive remedy, and I would submit that that one is entitled to say my extradition proceedings, which affected my civil rights, were not determined within a reasonable time, and that's a different issue, because the lapse of time issue is a broader issue. The lapse of time issue is very often is concerned with lapse of time before you're even, as it were, apprehended, and it's a lapse of time from the time of the original offences, according to Kakis. So you're really saying, so long has elapsed between the time when I allegedly committed the offences and the time of extradition, that it'd be unjust or oppressive to extradite me. This is a different complaint. This is saying, in the extradition proceedings themselves, conducted in, so it's not a complaint against the requesting state, you've taken too long and it's now unjust or oppressive. It's in the proceedings, the extradition proceedings in the requested state, that's to say Bahamas, there was an unconscionable delay in the determination of this issue, and that violates my constitutional rights. So I think it is my lord, I respectfully submit they're not coextensive.
I understand they may not be coextensive, but in fact, there's a considerable body of case law that's grown up around unjust or oppressive since Kakis.
I accept that.
Which applies to the question of passage of time in extradition. But if you're right, and there's a broader remedy, that drives a coach and horses through the specific provisions in the Extradition Act in relation to passage of time.
Well, my lord, it would only occur in certain cases, because it would only occur, I mean, if I can call it, the paradigm case is something like Kakis, where the requesting state has sat around and not sought the person, and then they seek him 10 years on, and he says, well, you left me free as a bird, as it were, for 10 years, and then came after me. Due to that lapse of time, it's oppressive. This is a much narrower complaint to do with the conduct of the proceedings, which attract a constitutional right. So, my lord, what we do accept is that the court address the issue of whether it would be, as it were, unfair, and left that to the requesting state to deal with that, whether the overall lapse of time had resulted in an unfairness in respect of trial, or whether it was oppressive. This point, it was taken in the Court of Appeal, although they don't deal with it, but I accept that it was taken orally and Pomachowski was cited, and it's not dealt with. But I do respectfully submit that it is a different point. And my lords, that's the way we put it. So we say it's not coextensive with the passage of time jurisdiction. It really addresses a different type of complaint, and that the failure in the requested state for the matters to be progressed properly is a much more limited and focused issue, which implicates a very specific constitutional right. Sorry, Madam. Yes.
The remedy that you seek under the Constitution is discharge of the appellants, and that is exactly the same remedy that you're seeking under the Extradition Act. So yes, the remedies that you're seeking are coextensive, and the Constitution, Section 28, contains the proviso, which is at page 1693, and that is that adequate means of redress are or have been available to the person concerned under any other law. And the adequate means of redress are at page 1723, which is the relevant provisions of the Extradition Act.
Yes.
You haven't sought any additional remedy under the Constitution that would be available to you under the Extradition Act.
Well, I suppose, my lord, the very fact of declaring that there had been a breach of constitutional rights would in itself be the necessary first step to.
Is that the remedy that you're now seeking?
Well, my lord, I certainly say that there should be such a declaration, because it may be, but my lord, that would be a necessary first step. But it's true, my lord, that we do say, and we're relying on Henfield and Dharmalingam there, that the declaration would not of itself be enough. But we do say there has been a violation of constitutional rights.
So
I suppose. Yeah, sorry, my lord.
Well, the requirement is not to rely upon the Constitution if it is satisfied that adequate means of redress are available to the person concerned under any other law. The adequate means of redress are available in relation to discharge or anything else in relation to the extradition. Yes. The only question would be whether you could make a declaration as a means of redress under the Extradition Act.
Well, I suppose it might be of assistance to them in the future, whatever the outcome of these proceedings, in terms of a return. So, my lord, to that extent, I say it would the recognition that there has been a breach of constitutional rights would not be nugatory. But I do accept that obviously the reason why it arises in these proceedings is that we want to put an end to the extradition request, and I frankly accept that is the main objective.
And that means of redress is available under the Extradition Act.
Yes, my lord. And in relation to that, I accept that we haven't. The main reason being the decision in Fuller, where there'd been a delay of 20 years, and the board in the end said, well, it's not unjust and oppressive. So, my lord, that is the reason that we have sought this alternative route. My lords, I think that I'm nearing the end of my allotted time. If there is anything I can assist with further, those Those are my. Obviously, I pray and aid the arguments set out in detail. My lord, I would just, to the extent that where the Court of Appeal keeps saying they had it all along, they had the documents all along. What they had all along was, or what they had access to along was the rough copies, and it's quite clear from the terms in which it was being put was what they were seeking was the certified copies, which they never got. Now you may say, well, why they should have just made do as they did in the end, the rough copies, but it's not fair in that respect for the court to say you had it all along, because what was being sought was proper certified copies of the evidence. Hearing. But that I accept is only a response to the point made by the Court of Appeal. You had it all along. It isn't a response to the point, well, you didn't press for an early determination of the proceedings. We accept that we didn't press for an early determination, but we didn't stand in the way of it. Indeed, we cooperated with Mr. Braithwaite when he was asking for a date when counsel would be available in 2010. And Mr. Gomez gave his times and said I can do a hearing in, I can't remember when it was, but a particular month in 2010. And nothing happened until 2015. So my lords, we do pray that in aid. And so
Thank you, Mr. Fitzgerald.
those are my submissions.
Thank you very much. Yes.
My lords, dealing with the first issue, namely authentication, by way of introductory remarks, the answer to my learned friend's submissions is straightforward. The magistrate was required to be satisfied of two matters before she could commit the appellants to await surrender. First, that there was evidentially a prima facie case on drug smuggling against them. And secondly, the offences of drug smuggling were extradition offences. On the first requirement, there is no dispute as to the sufficiency of the evidence coming from the prosecution witnesses. Only a technical dispute as to the absence of certification, allegedly rendering the evidence inadmissible. We submit that the affidavit evidence upon which the magistrate found a prima facie case of drug smuggling was certified in 4 separate ways, any one of which is sufficient to make that evidence admissible before the magistrates. And just so your lordships have it, we set those 4 routes out in paragraph 16 of our case. In short, they are each affidavit was certified by Karen Atkinson. She was an officer of the court of the requesting state. Secondly, each affidavit, including the affidavit of Karen Atkinson, was certified by United States Magistrates Judge Anne Vitchinak. Thirdly, the affidavits were certified as a whole by Lister Brake. She was the Associate Director of International Affairs. And fourthly, if necessary, the affidavits as a whole were certified by Colin Powell, who's the Secretary of State, i.e. a foreign minister in charge of the US Diplomatic and Consular Corps. And as your lordships know, then in the normal way, each and every affidavit was authenticated with the seal by a ribbon being put through it and the Secretary of State attaching the seal. On the second requirement for the magistrate, namely were they extradition offences, that was supplied in the testimony of Karen Atkinson and also in the text of the US statutes she exhibited. And finally, if that not be enough, it was within the certificate of the Minister of Foreign Affairs. So, my lord, each of her exhibits of US law were also, and this was the point brought out in our paragraphs 36 and 37 of our case, were additionally certified not only by her as an officer of the court, but they were received in US proceedings. And we do say it's just obvious there were US proceedings afoot. And finally, the certificate of the minister was itself admissible by virtue of section 14(5), which we've looked at. Can I just, before I turn to make good those points, just deal with one or two of my learned friend's points he made in oral argument. The first point, which my Lord Stevens put to my learned friend, was the authority to read not a sufficient certificate for the purposes of section 5.3. If my lords can just turn that up, it's at page 16 in the electronic bundle. We looked at it at the very beginning. And I just would like to bring your lordship's attention to these words, which are in the certificate. This is, in fact, a certificate issued, as we shall see in a moment, pursuant to section 8 of the Extradition Act. It is the authority to proceed. It doesn't mention section 8, but it is, in fact, the authority to proceed issued pursuant to that section. And importantly, the important words, could I just ask your lordship to note, so in the middle of the page, where the minister says, I'm satisfied that the offences against the laws of the United States with which Nathaniel Jones, he issues 3 authorities to proceed, are accused. And then these words, are offences provided for in the extradition treaty with the United States. So he's actually certifying that they are, in fact, offences within the treaty, which therefore extradition offences. He then uses the precise words required by section 5.3, the acts and omissions constituting the offence of drug trafficking. Now, my lord, one of the reasons that these type of provisions are put in is because it's a provision of the Vienna Convention on Narcotic Drugs that these offences are always extraditable offences. So this is simply a way of making that certificate, and it completely complies with section 5.3, and it's issued pursuant to section 8. So in many ways, that's a complete answer to the extradition offence. My learned friend now brings out, well, there was an onus on the requesting state to deal with the statute of limitations. And in respect of that, he relies upon the provisions in section 7.1. I'll just set out what we say before I take you to it. Your lordships will remember, I think there was some discussion between my Lord Legate and my learned friend about where the onus lies in section 7.1. Well, section 7.1 simply sets out defences and pleas in bar. In fact, 7.2 itself is a plea in bar. And I'm helpfully reminded by my able assistant here, Miss Olawumbe, that actually I appeared in front of my Lord Lloyd Jones in the case of Lama. And for your lordship's note, it's 2014, England and Wales Court of Appeal Crim 1729, paragraphs 112 to 13. My lord specifically held that the onus on pleas in bar, as we know, are on the person making the plea. It's quite clear that all defences, such as abuse of process and proving that you won't get a fair trial, and plea in bars, need to be raised. And there is no requirement on the requesting state to rebut them in advance. In any event, it is dealt with, as your lordships have seen, my learned friend took you to it, at paragraph 18 on page 42 of the electronic bundle in the affidavit of Karen Atkinson. So, Lord, and one final point, just to make it clear, a point again brought up by my Lord Legate, dealt with by my learned friend, was whether the treaty had any application. It's trite law in a dualist constitutional system that treaties, unless they are incorporated into law, have no effect my Lord knows all the cases, J.H. Rayner, the Crown and Lions, and the various other cases which deal with that. So that the treaty in this case has no effect in law, save for, there is one point which I accept my learned friend's right. It may be necessary to reference it in order to find out whether the offence is within the treaty under section 5.1b Roman 2. But my lords will see that the treaty doesn't play any effect when we look at the statutory scheme. Can I just show your lordship the scheme and some authorities on how to approach certification? If we just glance at the Act, your lordships have it beginning at page 1710. And if I just pick it up at page 1712, and one can see that this is an Act to make new provisions. Just so your lordships have the legislative history, prior to 1994, when this Act was first brought in, extradition was governed in the Bahamas by two acts. The Extradition Act 1870, which dealt with foreign states, and Commonwealth countries under the Fugitive Offenders Act 1967. Both of those are before the Bahamas became independent in 1973. So the Imperial Acts were extended to the Bahamas. And your lordship's been shown section 15 in the 1870 Act, section 11 in the 1967 Act. We may come back to it, but it's quite clear that that is part of the legislative history which gives colour to the 1994 Extradition Act. I accept, of course, it on the face of it, it's a codifying act, not a consolidating act. So one has to take that approach to statutory construction and one look at new provisions. But it is certainly clear that it was codified in the light of the two earlier acts. And my lord, if we then just have that open and we start at 1712, the definitions are there set out. And before I take you into the Act, can I just try and bring it to life a little for those members of the board who may not be quite so familiar with extradition in these circumstances? There is, first of all, an executive phase when the minister looks at the request and issues an authority to proceed. There is then the judicial phase when the courts consider the questions set out in the Act. And then there is finally an executive phase when the minister makes a determination on surrender. What we're dealing with at the moment is the judicial phase, which is where the courts deal with the specific provisions. And of course, part of our submissions is that compliance with the treaty falls to the minister in the executive phase. And there are a trilogy of English cases from Sinclair onwards which make clear that is the case. So if we look at the Act, which was set up as machinery for giving effect to extradition arrangements and treaty obligations, if we look at section 4 of the Act, which is on page 1714, your lordships will see that the machinery is set up to allow an order in council to be passed, putting in arrangements for extradition, and the minister can subject such provisions to exceptions, adaptations, or modifications. Now, in fact, if we go on to page 1733, it's tab 4 in volume 1 of the authorities for my learned friend, we see the order in council which applies the Extradition Act in the Bahamas to the United States. But for whatever reason, there are no adaptations, exceptions, or modifications. In the old scheme, the Secretary of State used to put in treaty provisions there, if applicable. So here we have a scheme which is entirely dependent upon the Act, and the treaty is not engaged because there have been no exceptions, adaptations or modifications. We've looked at Section 5, which sets out extradition offences, and as your lordships know, we rely on 5.3. The restrictions we've also looked at, which are general. Section 8 at page 1718 deals with the issue of the authority to proceed, which again we've seen on page 16 of the bundle. And again, we looked at in the judicial phase, section 10.5, and those are the twin points, which I pointed out to my lords earlier, that the magistrate has to be satisfied of, namely its extradition offence and prima facie case on the evidence. And at section 12, we return to the executive phase, whereby the minister returns to make his final decision on surrender. And we have, as we've seen, section 14 giving effect to the provisions. On the point about section 14.6, which was raised before your lordships, and my learned friend said, well, that deals with something independently. We disagree. It clearly is a freestanding provision, which is often used. It is often used in the magistrates' court for oral evidence to be called. It can also be used in other courts which allow affidavit evidence. I think, in fairness, what my learned friend may have been alluding to was that in the magistrates' court, it is not normally possible to adduce affidavit evidence at a committal. However, as we go further up the chain, the Supreme Court does, under its rules, allow affidavit evidence, as indeed does the Court of Appeal. So section 14.6 can be used in any of those ways. And there are any provisions, any evidential provisions which are available, which would otherwise be available to a committing magistrate, would be available in this case, because your lordships will see in section 10 that under section 10.1, that the magistrate has the same power as a examining magistrate and deals with the case in the like way. So he can, so anything which would be available to the magistrate in a domestic committal would be available to the magistrate in an extradition committal. Similar, with that short gallop through the Act, can I just take you to, in fact, an interesting case on authentication. It's Ram Charan, and my learned friend mentioned it, but we didn't look at it. And I would just ask my lords to look at it. It's at electronic bundle page 312. I'm sorry, that's the wrong reference. It's in the authorities.
.204.1.
I'd left the last thing off on my note, my lord. That's right.
Sorry.
It's your lordship, just give me one moment. I don't know why I've just got the wrong provision. It's the case in Jamaica.
2029 is where it starts, and Lord Stevens gave a reference to a passage we've already been shown in that case.
Right. It's tab 22, it's page 2029, but there are just one or two passages I would just like to draw your lordship's attention to, because it gives a general approach to the issue of certification. Your lordships see the case begins, it's in the West Indian reports at page 312, And can I just draw your lordship's attention to electronic bundle page 2039, that's 322 at B. Now, we see the court there says at B that the purpose and intention of the section are to ensure that the documents relied on by both the requesting and the requested states are genuine and authentic, as originating from original sources and not contrived and falsified in order to procure the transfer of its nationals by devious means. And we'll see in a moment, or in fact, if one goes back a page to 2038, one sees that the words of section 14 are in pari materia in the Jamaican Act as they are in the Bahamian Act, although they deal with section 14.2, it's section 14.3 in our Bahamian Act. If we could then just go over the page, and in fact, coincidentally, the court is dealing with exactly the same authentication as was made by Lister Blake. If one looks at page 2040, report page 323 between D and E, we see the original documents referred to by Lister Blake, and the certification is in the same way. We see that at the top of page 324, bundle page 2041. Again, the documents hereto annexed was further certified by Colin Powell, Secretary of State, and certified by Lister Blake. Now, what I just draw our Lord's attention to is that in the judgment of Justice of Appeal Cook and then Harris, let me just check that. The Justice of Appeal Cook begins at bundle page 2066 at 349. And what is interesting, if we go to page 2068, a report page 351 at I, at the last few lines on the page, electronic page 2068, let me state at once that certification does not demand a formal declaration to that effect. It's unnecessary to be the words "I certify." It is sufficient if the impugned document evidence is the appropriate insignia, which can be properly regarded as statutory certification. And if we drop down a few lines on electronic bundle page 2069, report page 352 at C, you'll see there that the learned judge accepted that the mere signature of the United States Magistrate Judge for the Southern District of Florida was sufficient certification. And we say that's important because all our documents are hereby certified as well by the judge. And just for completeness, Justice of Appeal Harris, who begins at page 2076, report page 359I, then deals with certification again. You'll see, just glancing through at page 2083, that he deals with the identical certification as we have in our case by Lister Blake. And at 2084, report page 367 between B and C, we see the same bundle. And interestingly, electronic bundle page 2085, report page 368G, second main paragraph from the bottom. Second sentence, nor is it a requirement specific words must be expressly used identifying the documents as certified to be originals or true copies. It must have been in the contemplation of the legislators that once affidavits are duly sworn to, and such affidavits together with the documents are contained in the bundle, the certification of that bundle of the duly authorised officials as prescribed by section 14.2a of the Act confirms their integrity. And again, he deals with, just for completeness, 2087 report page 370A, accepting that the signature of a judge is sufficient. So, my lords, if we just pause there for a moment, what we get from that authority is the following. One, that the signature of a judge on the documents is itself sufficient certification. It complies with the statutory purpose. Indeed, my lords will know that is exactly the position which pertains in England and Wales under the 2003 Extradition Act. The signature of a judge or magistrate, or in that case, officer of the state, is sufficient. And we say that is so here. And we also get from that case that a formal declaration is not required. So, with that in mind, if we turn to the actual certification of the evidence in this case, can I just ask your lordships to turn up the evidential bundle? If we turn to volume 1, my learned friend.
There's a question from Lord Leggett, and then a further question from Lord Stevens.
So,
did Lord Gifford take a point about Miss Blake's adequacy of her certification, or was the act the same as this one? I mean, as to requiring an officer of the court.
he didn't take an act. He didn't take this point, my lord. No.
Is the legislation similar in that respect? In that
The legislation in my
has to be certified by a judge, magistrate, or officer of the court.
the legislation is identical, my lord. I just to show, my lord, that the provision which sets out section 14.2a is identical to our section 14.3a. I think it's slightly out of kilter because the Bahamians have put in a passage 14.2 about inadmissible hearsay. So, but if one drops down and goes to the wording, it's electronic page 2038, and pick it up between C and D, you'll see that under the Jamaican Act, the words are identical under section 14.2a of the Jamaican Act as they are to section 14.3a under the Bahamian Act. And the point was not taken. My Lord Stevens, I think, had a question.
Yes, well, ordinarily when a document is sworn before a judge, the judge isn't certifying that it is, if you take it literally, that the document is either an original or a copy. And if you approach section 14 literally, there has to be a certificate that what is being produced is either an original or a copy. And I thought in the reading of this authority that the court itself looked at the affidavit and said, well, the certificate is deficient insofar as it doesn't say it's original, but we've looked at it and it is original. And so I thought that was the way they got around it.
I think my Lord is right. But we do say that it doesn't need a formal declaration because it simply needs to be a port to be certified by. Certified is a legal attestation. And we would respectfully say that it is sufficient for the judge to have signed it. If we're wrong about that, we fall back to one of our other methods of certification.
Well, I can see a court having a look at a document, but potentially, as this court did. I think it's at page 2041, 2044, and 2043. But how is it certified as being a copy?
Well, can I just take you to the actual documents, my lord, because it's easier to see it from the documents itself. If, for instance, we go to page 74
Yes.
Now that 74, by way of example, is the affidavit of one of the Drug Enforcement Agency special agents, a Christopher Maffez. And he gives evidence because he sees, one sees that in paragraph 7, from the C and double boat, 350 kilograms of cocaine, which was in the forward lockers. But if we go over the page dealing with the point we're engaged with, at page 76 of the electronic bundle, you'll see that the attestation is sworn and subscribed to me before me this 24th of January, signed by the judge. So we do say that one can get from that a sufficient certification because the affidavit was sworn and subscribed to him on that date and therefore was before him. And that would be, we would say, a sufficient certification. And it certainly meets with the purpose of ensuring that these are official documents which are coming before the court.
But isn't the certificate supposed to declare whether it's a copy or an original?
My Lord is right on section 14. My Lord is right. We know it's an original. Either we would look at it. We actually know it's an original because if we go back to bundle page 53, and I accept this isn't in his certificate, but it's evidence which was before the judge. At item 5 on page 53 of the electronic bundle, one sees that it's stated by Karen Atkinson to be the original affidavit. So what was before the court was the original affidavit. So even if we adopt the approach that my Lord rightly said was adopted in the Jamaican case, had this point been taken at committal in front of the magistrate, she'd have been able to see that it was in fact the original. So we do say that that is a route to certification. It's our second backstop, if I may put it in that way. Our first primary position would be that in any event, they're authenticated by Karen Atkinson. We've seen that where she sets out her declaration, which, contrary to my own friend's submission, we do say is and can be read as freestanding. You don't have to put a certification in itself in an affidavit which has to be certified. Otherwise, it becomes a self-fulfilling prophecy. It would never end. I think my Lord Legate made that point. You'd always have a further document to certify. The certification itself can be done by any of those persons within the meaning of the Act, and she certifies it's an original affidavit. So that in itself is a primary route without even dealing with the Lister Rake approach. And also, I see the time.
Could you just help me on this, Mr. Lewis? What's your first backstop?
Our primary position is that Karen Atkinson certifies so far as prima facie case is concerned. Our second position is that the judge certifies the affidavits. The third position is that Lister Rake certifies because she mentions the words with attachments, which is added in, and certifies. And our final backstop would be that Colin Powell was the certifier because he's a diplomatic, he's Secretary of State for the Foreign Office. So he could certify and does certify the document, and it's taken as a whole. But on each and every one of those routes, we say that there is some good argument to the prima facie case.
And this is all limited to prima facie case?
at the moment, I'm just dealing with prime facie case, my lord.
Yes,
Yes.
yes. Thank you very much. If that's a convenient moment, we'll resume at 2 o'clock.
Thank you, my lords.
Thank you.